All right, everybody, we're live and we're welcoming you to Senate Corporations. The first bill for our consideration is Senate File 64, Malt Beverage Manufacturer Amendments. Is anybody here to talk on that bill? Is a sponsor here? How about if we set that bill aside till Senator Nethercott arrives? And then we'll just go right back to it. Is that all right? Okay, the next bill for our consideration is Senate File 93, Limited Liability Company Reporting. Senator Lannon, would you mind taking the committee for a little bit? This is a bill that I'm sponsoring.
Glad to do so, Mr. Chairman. Senate File 93, sponsored by Senator Case. Senator, maybe you can walk us through Senate File 93 and help us know what we're doing here.
Thank you very much, Mr. Chairman. Earlier this year, and even a little bit in the past last year, there was lots of discussion of a thing called the cowboy cocktail. I don't know if you remember, but it involved a situation where a trust would own an LLC, and then a business would be performed through the LLC. We talked about it a little bit in Revenue Committee. In Wyoming, the LLC form can be very anonymous. You have to have a registered agent, but you don't have to disclose the ownership of the LLC. The registered agent has to be able to serve the owners with any kind of subpoena or paperwork, but you actually don't have to disclose who the officers are or anything like that. It's a little bit extra complicated when a trust owns the LLC, and the fact that a trust doesn't have to register at all with the state of Wyoming. There's no requirement. There are some voluntary situations where they do so, but so there was lots of news accounts of this being abused, in that a trust that was anonymous and could be a foreign trust would own an LLC in Wyoming and conduct business that way. What this bill does is to close that loophole and just say that if a trust owns an LLC, they have to provide more information about the identity of who owns the LLC. It defines beneficial owner at the very last of page 2, and that's the gist of it. If a beneficial owner of the limited liability company or foreign limited liability company is a trust, the statement shall include the identity of the trust and the identity and contact information of the trustees of the trust. And so that's the bill that we're talking about. I have had great help from the Secretary of State office, and I would be remiss in saying that they feel that there's a financial impact to the Secretary of State of this, and it's relatively small, but it would involve some programming. We might want to add that, and we can hear from them. Also overplaying this is there's a new federal law that's coming into effect that will require more disclosure of all business entities. And so that is slated to maybe come into effect at the end of next year, but we will have to see. So that's all I have. I know the Secretary of State's office is here, and I can see there are other practitioners, some old friends in the business that would probably like to address this.
Okay, Senator, thank you. Members of the committee, questions for the sponsor of the bill? Questions for Senator Case? Senator Scott.
Mr. Chairman, I confess I've not seen the bill until about 2 minutes ago. But, Mr. Chairman, my general question is, in this day and age where various ideological factions are harassing people for owning and operating certain kinds of businesses that are perfectly legal, but they don't approve of for various political reasons, there's some reasons we haven't had before to use mechanisms like this to preserve people's privacy and preserve their ability to go in and do businesses which are perfectly legal, like gun operation, manufacturer, distributor, something like that, that they just as soon not have out in the general public and get personally harassed for doing it. And I throw that out as a general question for anybody who's not a sponsor, but for anybody who's going to speak on this.
Senator Case, any thoughts on that front?
Mr. Chairman, I'd be happy to, and then I'd point out that Senator Nethercott is here. Maybe we could set this aside and go back to the first bill on the schedule. But Senator Cott, certainly in the instances we've heard about, the LLCs are all in legitimate businesses. I mean, you may disagree with them or what have you. It's that they may be helping to hide and disguise ownership that came of a dubious nature. More that not the business activity is dubious, but that the investment or the beneficial owner. There was allegations, I think they were remarkably perhaps unsubstantiated, that foreign oligarchs, Russian oligarchs could use this way to hide ill-begotten gains from around the world. So that was the gist. It's more about how the loot was got rather than what the activity of the LLC is. But Mr. Chairman, if I promised Senator Nethercott she'd get top billing here today, and I hate to steal her thunder. Is it okay if we set this bill aside?
Absolutely. And Senator Scott, are you okay with that? We'll come back. We'll come back to this conversation. I think it's a good bill, worthy of some debate and consideration. But back to you, Mr. Chairman.
Okay, thank you. We'll take back up. We're going to set that bill aside for now and take back up Senate File 64, malt beverage manufacturer amendments. I'm very excited to hear all about this bill. Me too. Senator Nethercott, welcome to corporations.
Thank you, Mr. Chairman. Good to be here in front of Senate corporations. As communicated to you previously, good news, Senate corporations, the two parties who are affected by this bill, primarily the craft brewers and the distributors, have come to an agreement to work together in the interim. And so the need for this bill is no longer. And so I'd ask that you either vote to kill it or table the bill as we watch those two industries recognize the changing commercial market patterns and work towards a solution during this next interim. Thank you, Senate corporations.
Wasn't that riveting testimony? No, let's not let her get off that easy.
Darn, I was
No
gonna-
way,
I was
let's
gonna
not
make
let her
that
off that
motion, and the
easy.
senator got out in front of me. Would have been the only motion you guys have supported the whole session.
Any questions?
And Mr. Chairman, if I may, that was previously communicated to the chairman, and so I hate to take up your time this morning on Senate File 64 in light of that good news. But no, it's helpful to hear that in the open air and make sure you feel comfortable with the communications to the chairman.
Thank you, Senator Nethercott. And Senator Barlow, it's a very good motion, and it's not even debatable, but would you mind if we see if anybody else was here to testify on this bill? Thank you. Would anybody else like to testify on Senate File 64? Anybody want to say anything?
Well, they did, but now maybe they don't.
They're all shy. Okay, well, anybody online? Thank you, Kelly. Okay, so now I think we're open for a motion. Senator Barlow. Okay, motion is to table. All those in favor signify by saying aye.
Aye.
Opposed, no. Probably should do a roll call on that, but it was unanimous. Nobody's ever going to see that. Back to Senate File 93, Limited Liability Company Reporting. Back to you, Mr. Chairman.
Okay, Mr. Chairman, thank you. We were still, as a committee, taking up a couple of questions that we had of the sponsor. And Senator Scott, we're talking about the need for identification of the trustees of the trust, I believe, and you had a question when we went to the other bill. Go ahead, Senator Scott.
And Mr. Chairman, I appreciate the argument that the anonymous ability could hide ill-gotten gains and that sort of thing. But a fair amount of that is in the eye of the beholder. And we are in a society where various politically correct elements, to be blunt about it, Mr. Chairman, are starting to harass owners of particular kinds of businesses. And including some that I think most of us here in Wyoming would approve of. That is the business and the gun operation, one way or another, would be one of those. But it may well spread to people who run various fossil fuel companies. And I'm wondering if the need to give those people some anonymity in what assets they're owning so they don't get personally harassed is starting to outweigh the fear that some foreign outfit may come in with something that we all don't really approve of. So, Mr. Chairman, I'm throwing that out and would be very interested to hear what any of the practitioners say.
Thank you, Senator Scott. You know, when I read this bill last night, Senator Case, it harkened back to all of the transparency work that we've done on this committee over the past 5 or 6 years. And I guess I didn't react as quite as much as Senator Scott did, more to the transparency piece. But any thoughts to Senator Scott's concerns there, Senator Case, or if not, we can.
Well, Mr. Chairman, thank you.
Testimony.
I mean, kind of looking at the world here, I think Senator Scott is suggesting that we should give owners more anonymity, not less. In Wyoming, all our business forms, it's the LLC that we can use this registered agent to avoid declaring the beneficial ownership. You know, if you do like a C Corp, you have to list your officers and things like that in the annual report. So it's kind of unique to the LLC. I don't know if that's necessarily a good thing or not. Certainly the federal government seems to have gone past that and moved past anonymity with the bill that's been passed and is coming down to be implemented. The case of the trust is particularly hard to figure out what's going on, and it was I don't know if you recall the news reports. I think it was even the New York Times referred to something called the cowboy cocktail, which is the so-called formula of a trust owning an LLC, and you know, trusts are anonymous. LLCs are practically anonymous except for the registered agent. And you know, there were all those photos of that house in Cheyenne that has so many LLCs, and on and on and on, that maybe we were promoting either bad activity at the LLC level or bad sheltering of assets that maybe came from elsewhere. So that's the gist of the bill. It actually came out of revenue. The bill itself didn't come out of revenue. That's a misspeak, but we discussed it at our first revenue meeting in the interim and had several of the practitioners, some that are here now, come and discuss this, and people that are in the trust business, which Wyoming has a huge trust business, by the way. I mean, there's some big money, especially in Teton County. So I think maybe, Mr. Chairman, we could hear from other folks out here, and I know the Secretary of State's office has concerns that we need to add a little money to the bill, but I'm sure there's practitioners that want to address this.
So committee, I'm inclined to do that if there are no more questions of the sponsor. Let's go to testimony on the bill. We are looking at limited liability company reporting Senate File 92. Who would like to testify on this bill?
We do have the Secretary of State. I don't know if they want to go first or.
Oh, you know, my apologies, Mr. Chairman. You're exactly right. So Secretary of State's office, please come up. I apologize. We would like to hear any perspective you have on this.
We're double teamed.
Well, and the timing is pretty darn
Pretty
good, really. I
impeccable.
mean, you know, it just blows in the door the minute we say Secretary of State, he's here.
He doesn't have
So,
far to go.
By golly, well, take it away. Mr. Secretary, Senate File 93, limited liability company reporting. You're aware
Right.
that that's the one that we have up this morning, and we've just begun discussions on the bill, and so.
Yeah, I was watching.
Interested in your perspective. Take it away.
Thank you. And so I'm Chuck Gray, the Wyoming Secretary of State, Mr. Chairman, and to my left is Jordan Gray, the head of our business division. Just for the media, there's no relation, and our names are spelled the same. But we're really excited about Ms. Gray and her work on this as the business division head. Good morning, Mr. Chairman. I have no objection to SF 93. You know, I really saw during the campaign, this is an issue I think we need to get a handle on. Talked with Representative Sith about it yesterday and look forward to working with the entire committee and Chairman Case on it. I think SF 93 could be beneficial to the state of Wyoming because it will allow the public to know when a trust is the beneficial owner of a Wyoming LLC, which could be beneficial given concerns that certain European oligarchs or some of the reporting that they're using Wyoming LLCs to hide assets. And I do think we need to not be in denial about the possibility here, which, you know, some of the rhetoric that in response to some of these reports that have been going on for some time, I think there's been an aspect of that denial. And I think we need to acknowledge this could be an issue. While it is crucial that Wyoming remain the most pro-business state in the nation, we should not allow foreign entities to take advantage of our laws for nefarious ends. This office can easily implement SF 93, which will require minor modifications to our WyoBiz application. We'll have to modify the program to allow LLC filers to disclose whether a trust is a beneficial owner of an LLC and disclose information about the trusts that are beneficial owners. Making these modifications will cost the office about $10,000, and we would ask this committee to consider re-referring this bill to cover those costs. Thank you.
Hey, let's go to Ms. Gray. Anything you'd like to add to the Secretary's comments this morning? Ms. Gray, welcome.
Thank you. Good morning, Mr. Chairman, members of the committee.
This is Ms. Gray. This
Sorry.
room is one of those rooms they were examining this weekend as we had some folks in our Capitol trying to figure out how we can improve the acoustics.
All right.
And boy, does this room need it. So stay right up close to the microphone for us. Thank you.
Sure. I don't really have much to add to what the Secretary has said. As you have discussed, the LLC really doesn't have to provide our office a lot of information when they register with us. They have to provide the name of the LLC, their registered agent information, so the name and address of their agent who has to be in Wyoming, and then the name of the organizer of the LLC. So we do not require to know ownership information. It is required to be known by the registered agent, which has been discussed already. So LLCs are the number one entity type that's registered with our office. About 81% of all entities registered are LLCs. So that does make up
Ms. Gray, what was that percentage again?
81%.
81%.
So 78% domestic LLCs and then 3% foreign LLCs. And foreign just means that they are registered in another state and have qualified to do business in Wyoming. We consider them foreign. Other than that,
Questions of the Secretary of State's office. And, Senator Bartlett, and then we'll come back to Senator Scott. My apologies.
Thank you, Mr. Chairman. So either for the Secretary or the Business Administrator, do trusts also register with the Secretary of State, or are there trusts registered with the Secretary of State that are not LLCs? Thank you.
Mr. Chairman, Senator Barlow, no, so trusts don't register. However, if they are a trust company, like an LLC or a corporation, they do register with our office.
Mr. Chairman, on page 2, starting line 17, in this section, beneficial owner means a member of a liability corporation that owns. Is that definition used? I didn't find it in this bill. Is that definition used anywhere? What's the point of that definition being?
Ms. Gray, have you run across that?
Mr. Chairman,
Go ahead,
Senator
Mr.
Scott, I think the reason it's defined is earlier in the bill, you have the sort of the follow through, right? That's the follow through, and you got the wind up at the end. So it's kind of in reverse order. I think that's where that reference is important.
Okay, I see the time.
Okay, anything else, committee? Any other questions? Appreciate you guys being here. Thank you.
Mr. Chairman?
Senator Case.
If I may, I want to thank Ms. Gray and Secretary of State Gray for their courtesies while I was working on this bill. Thank you very much.
Thank you very much. Appreciate your time this morning. Let's go to further testimony on the bill. Mr. Meyer, good morning. Good to see you again.
Thank you, Mr. Chairman, members of the committee. Scott Meyer, and this time on behalf of Scott W. Meyer, PC, my own law firm. But what I want to talk about is I'm trying to figure this thing out. And my question is most straightforward is why? What are we trying to accomplish? Are we just being nosy, just trying to figure out who owns what? And I'm not sure where all this is going, but I will tell you that I spent, along with some of my other colleagues, and one of them's already in the room, an enormous amount of time with practitioners and with legislators, and thanks to the good senator from Fremont County, we were able to pretty much scrap and start over with our limited liability company bill. And this was done with a lot of great work. And I know that the good senator from Natrona County over here also worked on this very closely, and that we also did a lot of what we called back then home cooking. But part of the reason that we were trying to do that was to protect the anonymity. You don't want to have your business secrets, you don't want to have your business plans being shared just because all of a sudden somebody knows who you are. So I'm not sure exactly what we're trying to accomplish. Now, I heard a lot of testimony or comments about, the Little House on the Prairie. That had to do with the Panama Papers. And there was a lot of investigation, but I don't think there was ever anything proven that anything in Wyoming was done wrong. Then we heard about the Cowboy Cocktail and the Pandora Papers. And again, I don't think there was anything that was shown that was done wrong in Wyoming. I know that the Secretary of State made a comment about potential. But think about, I don't know what potential means. And I, again, go back to my first question, what are we trying to prove? When you look at this and it says, okay, a trust. Well, there's a lot of different kinds of trusts out there. And so we don't define what trust we're trying to look at. We don't define what we're trying to accomplish with that. And you can have a trust, and you don't even have to have a written agreement to have a trust. It can be oral agreements, as long as you're doing things in trust. So I'm not sure where you're going with that. With respect to like even estate planning, I can go out and buy a piece of rental property. I can put it in my sole member LLC, and I can have my trust own my LLC. Are you telling me you really want to know who's owning that rental property and for what purpose? And when I look back on it and think about all the work that we did, and then because of those Pandora Papers and what have you, there was new federal legislation. And FinCEN is even coming out now with, here's the rules that they're talking about their rules being published as of this month. And then the law will be enacted as of the 1st of 24. And those things do require, there's a lot of exceptions in there, but they do require the disclosure of who the beneficial owners in certain circumstances. So again, I'm really perplexed. I can't say that I can support the bill. I just don't know really under what case and what scenario we're trying to stop. We might hear that some oligarch may have something. We might hear that they might have some control of some assets, or they put money into Wyoming, but I'm not sure that's illegal. And I'm not sure why we want to know that. At the risk of all of our Wyoming citizens and the people that are looking to come to Wyoming to do business in Wyoming, as the Secretary of State's office said, 81% of the new filings are LLCs. We're doing something right. Why do we want to discourage that? Why do we want to say no? And by the way, we need to know who those beneficial owners, especially if it's a trust. I can't tell you how many times a lot of these trusts are used for estate planning purposes or for other purposes. And a trust can be, you can use a trust for a lot of things, whether it's just for a regular business. You can have trusts that are 501c3s. You can have trusts for a lot of things. So how are you going to define which ones are which and who's doing what and why? My question is, I'm just not sure after all the work that we did 10 years ago to put this stuff together, to make sure that we had the anonymity, to make sure that nobody knows that it's Walmart buying that property next door because the price will go up, and so they hide it in anonymity to make sure that they get a fair deal. To make sure that, especially in Laramie County, with all the work that's getting done at the military base, and with the missiles, all the businesses that are coming in here, there's a lot of reasons for anonymity. And to turn around and say, no, but we really want to know in this case, it sounds to me like a very dangerous slope. A very slippery slope. When you're looking at saying, well, now we want to know and we want to know and we want to know, but nobody can tell me why. Other than, yeah, there was a newspaper article. Yeah, we had some testimony about this, but I don't understand really where it's going. So those are my comments, Mr. Chairman. I'd stand for any questions.
Thank you, Mr. Meyer. Appreciate you being here. Committee questions for Mr. Meyer. Senator Scott.
Mr. Chairman, Mr. Meyer, I know you do quite a fair amount of corporate law and that sort of thing. We've dealt with you over the years on this. Is this we put this in, are we going to start telling some of your clients that really they need to go elsewhere or take some additional steps that they wouldn't take if they weren't doing business in Wyoming to preserve anonymity that they want? Because in some business, the New York Times doesn't approve of, and they might get harassed.
Mr. Meyer, go ahead.
Chairman, Senator Scott, I'm not sure that it would require me to say go elsewhere, but it certainly would require some additional planning as to what you want to do, to how do you accomplish that mission of trying to keep it anonymous. For business purposes, I think it means a lot of sense, so that you would have to start figuring out different ways to making it work.
Senator Case.
Mr. Chairman, thank you very much. I'd like to kind of maybe have a dialogue about the why. You mentioned, Mr. Meyer, that why would we want to know who owns that rental house? I can think of a lot of reasons why we'd want to know who owns that rental house, who's behind it, rather than just an LLC. Communities care about what happens in those houses or how the tenants are being treated, and I can think of things. I can also think of, you also mentioned an example of a large retail, maybe buying land for a store and picking up the land secretly. I think those people that sold their land might want to know that it was going to be for a large retail establishment like that. And I think they feel a little violated by that. So this anonymity is a two-edged sword. It has given Wyoming a bit of a bad reputation of being in the bottom of the world. I know it's also given us a nice flow of money. Secretary of State's office is a great moneymaker for the state of Wyoming. But I'm just not convinced, and I want you to push back on me, but I'm not convinced that why wouldn't we want to know that? And apparently that's the direction of the federal law. So help me with some of that.
So, Mr. Meyer, first time you've ever had a debate with Senator Case, but he does point to a little bit of the flip side of the issue. What say you on that?
Well, Mr. Chairman, I would say that at this point in time, first of all, the federal statute was a knee-jerk reaction. I think that they have a tendency to do that when they see some press out there, and I can get a lot of mileage out of it. I'm not sure it's going to do much with it because there are a number of exceptions. They list, as I recall reading when I first read it, about 23 different exceptions, one of which is including for the family-owned business. So that's all right. As far as the idea of the anonymity, maybe they want to know, well, maybe they do, but maybe that's none of their business. I look at this and I say, I don't think Wyoming's, I disagree with Senator Case. I do. I don't think we're at the bottom of the heap. I don't think we have a bad rap. I don't think we have any of that. I think that's the press. But I think the Secretary of State's office will show you that we are very popular and we continue to tweak our laws. It seems like almost annually we come up here with a little tweak here and there, whether it's corporations or LLCs or trusts. But we're always trying to be the big dog in the country on LLCs and everything else, and we do that very well. And people do want to come here. And we have companies from all over, entities from all over the world that want to set up Wyoming LLCs. And I don't think any of them, at least the ones I'm working with, have anything to be in anything nefarious. I think we just have good laws. And they do protect individual investors as to what they're trying to do and what they're trying to accomplish.
Further questions with Senator Boner?
Thank you, Mr. Chairman. Mentioned all the businesses coming in because of the Sentinel ICBM that's going to be deployed. And I just have to say, I'm also a co-sponsor on a bill that's going to limit foreign property ownership near critical infrastructure, including near our nuclear missiles that are based partially in the state. So as somebody who has operational experience in that capacity, I'm just wondering, I'd like to point that out, that we'd be naive to think that there isn't that sort of interference going on. It's not just a bunch of dollars being spent in Laramie County. There's a very real operational mission that's happening. And I'd point out that in Nebraska, Huawei is a Chinese, basically spy tech company that has wireless communications all throughout the missile field currently in our neighboring states. So I guess I don't have a question so much as a statement that there are reasons to be wary of businesses that want to come in and do work here. And I think the balance here is to not upset the apple cart, but I just don't see it in this bill, Mr. Chairman. So I guess any reaction from would be great, but I just listen to this conversation, having the background that I do, I think there are plenty of reasons, and I just wonder what the reaction is to that concern.
Good point by Senator Boner. Mr. Meyer, there are a couple of issues being discussed in other committee meetings, and they do touch on this a little bit. Give you an opportunity to visit with Senator Boner.
I'd be happy to, Mr. Chairman. I know that other states have done this, and I don't know about the constitutionality of that. It raises a lot of questions in my mind whether that's possible or not. And there may be, but this particular bill just singles out trusts. It doesn't talk about anything else or anybody else. And so that's why I'm looking at going, I'm not sure what we're trying to accomplish, what it is that is such a trust, just because we've heard of cowboy cocktails.
So, Mr. Meyer, I actually, I've got a question on that front. What really comes to my mind, having dealt with a trust, and it's not the kind of trust, I wasn't dealing with a trust like we're talking about this morning potentially, but it was nonetheless a trust. And if me and my siblings had decided to purchase land or purchase a building or anything on the property side that you alluded to, whatever, I was trying to think of why we wouldn't want people to know who we were. And that's where I struggle a little bit and find a little bit of comfort from that in this bill. Help me out with that. I mean, I guess the purposes of staying anonymous bother me a little. Can you expound a little bit on the reasons why you've got to be anonymous if you're a trust that wants to set up an LLC and do business and be a neighbor, purchase ag land? That's where I'm struggling.
Well, Mr. Chairman, I think that the concept there is, not so much as to why would you want to be anonymous, is why do you want to know? I think that, we have the Wyoming spirit here. We have people, we do our own thing, we do whatever we're going to do. But my clients, when I look at it, they say, you know what, I don't necessarily need to let the farmer next door know what I'm doing. If I'm trying to buy other property, if I'm trying to expand my farms, or if I want to buy the ranch next door. You know, I had a client that said he did not want to own the world. He just wanted to buy the guy next to him. All right, well, you start seeing how that's going to work and you figure out you're next in line. It might affect the price. Maybe that's okay if you're the buyer, but it's not okay if you're if you're the seller, but not okay if you're the buyer. The buyer says, look, I want to get what's a fair deal, not something that's just ratcheted up because I don't know. My whole thought was, it really is one of those things that I want to keep my business to myself. I don't necessarily need to share it with everybody else.
Thank you. Senator Barlow.
Thank you, Mr. Chairman. So I did also key on the fact that this is only limited to trusts, the way this language is, the beneficial owner. And certainly there's other types of business arrangements, limited partnerships, et cetera, that could be utilized in the same manner, I would argue. So my question, is there any other place in current law, federal or state, where the trust or the trustees are required to be disclosed? Thank you, Mr. Chairman.
Meyer, can you help us with that?
Well, Mr. Chairman, and there's a lot of people that probably have a better handle on this than I do, but I would think that if with like a revocable trust, no, the IRS doesn't consider that. They look at who's the grantor because you have control of it, so you just use those Social Security numbers, and those are the ones that are there. And as far as who's the beneficiaries, they don't really care because that's all revocable, it's amendable, it's changeable. It's a little bit different when you talk about an irrevocable trust, because now all of a sudden I've got a trust that's out there that really has set beneficiaries or contingent beneficiaries or what have you. But again, every one of these trusts could have a contingent beneficiary that may never come to light. All depends on who survives who or under what circumstances. So I think that those get identified with the Internal Revenue Service and others when they become irrevocable because they get set in stone. But a single member LLC that is a disregarded entity for the IRS, that's now owned by a trust, it's a disregarded entity for all intents and purposes by the IRS because it's revocable and amendable, all of a sudden it still is the same person in there. I don't think the fact that it has a trust has anything that is any special in it.
Okay. Mr. Meyer, thank you. Appreciate it. Hope you can stick around for a little while and we reserve the right to ask you another question.
Sure.
Okay, thank you much. Any further testimony on Senate File 93? Please come forward. We'd ask that you state your name and for the record, we are streaming live and it helps if you stay up close to that microphone, just like a sports broadcaster.
Thank you, Senator Landon, Mr.
Morning.
Chairman. My name is Tom Long. I am a lawyer here in Cheyenne, and I am here representing my law firm, Longreimer Weiniger, LLP, with offices in Casper now, Senator Scott. I would begin, I've made so many notes, I'm not sure where to begin. But I do want to mention that my law firm had provided to you, Mr. Chairman, a memo about the interim study that was being handled that I think was instigated by that Washington Post article that mentioned Carol Gonella's phrase, cowboy cocktail. And I'm not sure we've seen any articles since then of equal impact. But in that memo, we had indicated that there is nothing special about Wyoming law that aids and abets money laundering, tax evasion. And I guess I should begin by saying I think the bill is a bad idea. If you all think it's good public policy, your anonymity is another man's privacy, and that is a big issue. But if you resolve the big issue in favor of no more privacy on this particular platform that we offer in the state of Wyoming, then I think this is a very poor implementation of that idea. One being for the reason that this was not part of your interim study last year, and had it been studied, I think you would realize that it lacks an enforcement mechanism. Whose duty is it? The trustees, the organizers, who's going to have to deal with the consequences of disclosure? And so I am not sure who's going to get the blame if there is a lot of noncompliance. And I would suspect there will be a great deal of noncompliance from the get-go. I don't know that this will have retroactive effect. Well, I guess the annual report, the very next annual report. But many of the LLCs I form, the membership interests are owned by revocable trusts. That's the way we avoid probate. And so perhaps most of the LLCs I form would fall into the reporting category. I don't handle the reports, so I'm not sure who's going to get in trouble. I'm not sure who fills them out. I guess the duty falls on somebody to warn the people who are filling out the annual reports. I think that maybe the Secretary of State's $10,000 request might cover providing that kind of notification. But in any event, trusts have always been private. Trusts, ever since Henry VIII wanted to divorce Catherine of Aragon and Mary Anne Boleyn and had Parliament pass the statute of uses so that he could seize monastic properties and the use of modern trusts arose, they've been private. And to answer Senator Barlow's question about where are trusts disclosed, I think the answer is they are disclosed where people are disclosed. If a trust buys real estate, its name is on the record, just like if I bought real estate, you would know I own it. It's on the record. And that would also be true of trusts. You would see who the trustee is. And I think that is an appropriate decision made long ago that that information should be public. That's how we collect our property taxes and so on. So in any event, I think that the reason we do so well with our trust and LLC business in Wyoming is because other states are increasing their state income taxes and we have none. This business comes to Wyoming because of our tax base, our tax laws, not because we are offering some kind of special anonymity that other states don't offer. Trusts are not registered in any state other than statutory trusts, which we were on the forefront of creating. We were the first state to have LLCs. Some of us are old enough to remember that. And were around at the time, probably voted for it. And so I am not sure how much more I have to say, but I am certainly open for questions on why are we doing this? And again, I think it's a bad idea and poorly implemented if you think it's a good idea.
Tom, thanks for being here. I didn't quite catch your last name, Tom.
Long, L-O-N-G.
Okay, thank you so much, Tom. Appreciate it. Senator Scott.
Mr. Chairman, when I look at the competitive world out there for trusts of the kind we get, am I right in thinking that our principal competitors are Nevada and South Dakota? And did they subject people who would form these trusts and LLCs to income taxes in those states?
Senator Scott, yes, and you left out a couple of others. Alaska would make noise that you had forgotten them. And I should say, there is one other important question you had asked, Senator Scott, that my answer would be this. Years ago, I formed many Colorado limited partnerships because Wyoming's limited partnership statute had a bad element to it, which we have since gotten rid of. And so I don't do that anymore. I will tell you that I am fairly sure if this law gets implemented as it now reads, I will be forming Colorado LLCs rather than Wyoming LLCs for the reason that those clients may want their privacy. And Colorado's filing fees are cheaper. And Colorado is like nearly all other states. You don't have to disclose who owns the LLC. In Wyoming, you don't disclose who owns corporations, who owns limited partnerships. Up until this bill, we would not be disclosing who are the members of an LLC, nor who is the manager of an LLC. That's not even anybody's business. They'll find out if the LLC approaches them. In any event, Senator Scott, I answered more than your question.
Thank you,
so.
Mr. Long. We're going to keep clipping along. Any other questions for Mr. Long? Senator Case.
Hi, Mr. Long, how are you?
Fine, thanks, Mr. Chairman, and you?
Good. We have, Mr. Long has been practicing in Wyoming. He's, for a considerable period, he's extremely well thought of. And he's done lots of good work.
Thank you.
I'd like to drill down on the example you mentioned that if a trust owns real estate, you can go look at the deed. But if a trust owns that real estate through an LLC, really you can't do much more than eventually get to the registered agent.
Yes,
Mr. Long, go ahead.
Mr. Chairman, and recall that Wyoming adopted special legislation requiring the registered agent to maintain records so that there is a contact person. And so there is a transparency for any public purpose, law enforcement or whatever it may be. But you're right, it's private otherwise.
Okay. Go ahead, Senator Case. Follow up.
And Mr. Chairman, I guess that's kind of my point. There is this anonymity for owning if you're on the real estate with an LLC, which seems to be very common. Of course, if you have a legal reason, you need to serve them papers or you're suing them or, or law enforcement needs it, they can get all this information through the registered agent. But the public doesn't know who owns the real estate. You go look at a deed and it's going to say such and such LLC. That's all it's going to say. So anyway, that's kind of my point. Thank you, Mr. Long. Thank you, Mr. Chairman.
Mr. Long, thanks for being here. Appreciate it. We may fire a question your direction later.
I will stay, thank you.
Okay, further testimony on Senate File 93? Any further testimony? Do we have anyone online this morning that would like to testify on Senate File 93? Okay, nobody? Okay, we're going to close testimony on the bill. Committee, what's your pleasure on this bill? Okay, moved by Senator Case. Discussion. Senator Barlow.
Thank you, Mr. Chairman. So obviously, the good chairman has a lot more experience. All of you have more experience in this field of law. And while I may be a beneficiary and a trustee and several of the things, that does not mean I'm a practitioner of any of it, just a recipient. But one of the things that confounds me is when we have a definition in a piece of statute, in a section of statute, that conflicts with the same words in definition elsewhere in statute. And I just point out Title VII, the same title in Chapter 23 has beneficial owner, and it's a different definition, which is fine because this obviously talks to this section. But that starts confounding things when we have a definition that is, or words that are defined differently in the same title. And this actually happens to be in the Wyoming Statutory Trust Act, which was mentioned by, I think, at least one or both of the folks who commented on the bill. So, well, I don't quite understand all of what we're trying to get to with this. I do have a concern when we start using the same terminology and defining it within the same title with different definitions. And this one has a percentage, and what this one sees beneficial, and this one means any owner of a beneficial interest in a statutory trust. We start getting this, where are we? Is this, would this account for a statutory trust when we start talking about this language? So this is more, maybe more technical, not even trying to understand the broader implications, but more technically, does this confound the issue? Thank you, Mr. Chairman.
Senator Case.
Thank you, Mr. Chairman. I think the reason that we have to go down this route is because different corporate forms have different types of ownership. If you own a corporation, you own shares. If you're a limited liability company, you're a member. And so we got to trying to figure out how to deal with this to get at the notion that who owns or what owns the LLC. So beneficial owners is kind of a term of art, but obviously if it's an LLC, it's based on your member connections. If it's a corporation, it's based on your shareholdings. Here, it's, since they don't have those other entities, it comes down to be you own more than 50%. I kind of, it depends on where it's used, but I think it's clear that we're getting at what owns more than half of this company.
Go ahead, Senator Barlow.
Thank you, Mr. Chairman. And to that point exactly, is a trust the only type of entity, person, that could be so involved with an LLC? Thank you, Mr. Chairman.
Further,
think
go
there's a
ahead,
question.
Senator Case.
So I guess other entities can own LLCs. A C Corp could own an LLC, another LLC can own an LLC under some certain conditions. But I think the key here is a trust is completely anonymous. They don't have to be registered with Secretary of State's office, whereas the other entities do, or they're registered in some state somewhere. The only difference would be a sole proprietorship or a partnership that's could possibly own an LLC. You know, we're not incorporated. We didn't form an LLC. We just own it as a partnership. Potentially, you might want to expand that to those, but everything else would have a paper trail in a different direction, but a trust would not.
Anything further, committee? Are we ready? Final comments, Senator Case, take us home on this bill, and then we'll go.
So, you know what, Mr. Chairman, I do want to be sympathetic, or the Secretary of State's office was great to work with on this bill, and they indicated that they think it's a $10,000 change to their software. You know, you can do all these reports online. I'd like to help them out if that's appropriate, to give them the $10,000. You know, if the committee doesn't want to do that, that's okay. But I'd like to do that. They've been good to me.
Senator Case, that would be a conceptual amendment that would come in section 2 probably, and then section 2 becomes section 3.
We could appropriate $10,000 for the software upgrades necessary to accomplish this task in the Secretary of State's office. And they bring in a lot of money, so.
We can, Mr. Chairman, I think we can pass that as a conceptual amendment here, committee, and then go upstairs. Our legal staff can help us with that. Any discussion on the proposed amendment, Senator Barlow?
So to be clear, Mr. Chairman, since we are adding an amendment or adding money to it, it would automatically need to be re-referred to Committee 2. Is that accurate?
I think.
That is true. That is true. All in favor of Senator Case's motion on the amendment, please say aye.
Aye.
Any opposed, no. That amendment has passed. We have an appropriations on the bill now. We're back on the bill. Senator Scott.
Mr. Chairman, I still have reservations about this bill. I think that the privacy feature we've got does bring a fair amount of business into the state. I think that some of the people nationally want to breach these privacies, have political motives, and might harass people in businesses that they don't favor. We're having that problem in a number of the mineral businesses. that are falling out of favor with the politically correct left. And we know the people who manufacture guns and whatnot are out of favor with that crowd. And I think we're maybe going down a road that maybe we should not to. I think that there is the ability, law enforcement has the ability to get at the owners the way we have this structured right now in the testimony we heard, Mr. Chairman. So I think we might be better without this bill, Mr. Chairman.
So, committee, I'm really wrestling with this one. This is transparency versus privacy for me. And that's a tough lift on the policy front. I feel somewhat the way Senator Scott does. It gave me pause when we had, one of our attorneys this morning testified that probably from that point forward, he would be registering trusts in a different state. I certainly don't want that. I think that the good chairman has touched on something that maybe deserves a little more of our attention. The fact is we have a lot of outside interests coming into this state. And it's going to lead to a lot of discussions like this one right here. Senator Boner pointed to the fact that we've got a lot of entities coming in and trying to take over a lot of different things in our state. So this is a tough one, but I'm really struggling to get there. Senator, thanks.
That's fine. I just call for the question, Mr. Chairman.
Okay, question on the bill. Would you please take roll on Senate File 93?
Senator Barlow? Senator Boner?
Aye.
Senator Landon?
No.
Oh, that was hard.
Senator Scott?
No.
And Mr. Chairman?
No, aye. I almost got carried away with the majority. Aye.
Mr. Chairman, back to you.
All right, thank you. And Senator Landon, thank you for doing that. And just remember, they don't register trusts in Wyoming, they register LLCs. Nobody's registering the trust. But thank you all for coming. Thanks to my good friends, Mr. Long and Mr. Meyer, for always trying to put me in my place. They really are fabulous at what they do. So I think we are at 105, is that right? Is that the next one on our list? Let's see. Is that right? The next one on our agenda is 105. Okay. So Senate File 105, Utilities Point of Consumption and Allocation Agreements. Senator Steinmetz, welcome to the committee.
Thank you, Mr.
Thanks,
Chairman and committee.
Hold that
Okay.
microphone real close.
All right.
For some reason, this room has like an echo up above that's hard on all these old ears up here. Except for Boner, he's,
Is that better, Mr. Chairman? Can you hear me all right?
yeah.
Okay.
Keep it close, thank you.
All right, I will do that. Well, today I bring to you Senate File 105, and I'm sure that many of you on the committee are very familiar with this bill and the need for it, but I will go over the background and the need for the legislation just to be clear. For close to 100 years, the state of Wyoming has been divided into certificated service territories as it pertains to an electric utility's ability to provide electricity within the territory or boundaries. The reason for those territories was when the for-profit electric utilities decided that it wasn't profitable to build out to the rural areas of Wyoming, and they left it to rural communities and citizens, and they were without power. So they formed cooperatives in order to provide power for themselves, and these are the non-profit electric cooperatives known as REAs. And they were created by the citizens in those communities. To avoid duplicating services, multiple poles, wires, substations, etc., and to improve quality of service, reliability, and rates, those certified service territories were created, delineating boundaries where every electric utility was allowed to provide service. This system is commonly referred to as the regulatory compact. There have been occasions when utilities agreed to allow a neighboring utility to cross their CST. This type of arrangement is accomplished with a customer allocation agreement, which is an agreement between the two neighboring utilities and the customer requiring the service. The problem comes in and the need for this legislation arises because there currently are no repercussions, legal or regulatory, for a utility who violates or crosses into another CST. So basically, this violation, where everyone plays fair in the sandbox, creates a loss in additional electric load or member customer that is rightfully REA's, which in turn negatively impacts the existing co-op members because additional load, particularly in industrial or oil and gas load, helps with reliability and rate stability for all customers in the service territory. No repercussions for the violating utilities violation of law currently exist. A precedent could lead to future loss of load for other cooperatives if they are unable to service a load that is rightfully theirs. So with that being said, I bring to you Senate File 105. It does a couple of things. It basically says that there's a prohibition on providing service directly or indirectly to a customer in the public utilities certified area without a customer allocation agreement, certificated area, excuse me. And it allows for the recovery of damages, expenses, legal fees for lost income through a civil action. So that's basically what Senate File 105 does. And I'm sure you've read the bill, and so I would stand for any questions and may need to phone a friend for help with that. You've also been provided a map of where all the existing co-ops are and their certificated territories. So I hope that helps with the bill.
Thank you. Questions for Senator Steinmetz? Questions from the committee? Senator Barlow.
Thank you, Mr. Chairman. So to be clear, the mention was about the cooperatives, but this would actually apply to all public utilities in the state of Wyoming, not just cooperatives. Is that accurate? Thank you,
Senator
Mr.
Steinmetz.
Chairman.
Correct.
Anybody else? Senator Steinmetz, how are these situations handled now? What happens when there's, say, contested boundaries of service territory? I mean, we've been in business a long time. We've been through a lot of these. So how have they been handled?
Mr. Chairman, I think I know the answer to that, but I would like to phone a friend and ask if Sean Taylor would come up and join me and explain that to you.
Sure. Any other questions for Senator Steinmetz? Mr. Taylor, I guess you can be next. Thank you. Welcome.
Thank you, Mr. Chairman, members of the committee. Sean Taylor on behalf of Wyoming's Rural Electric
And
Cooperatives.
you don't have to start with my question, Mr. Taylor. You can back into it if you want.
Okay, I probably will, thanks. And I'm going to ask Mandy Good, our legal counsel, to join me up here as well, just in case we
Great.
go down any legal rabbit trails that I need to phone a friend for. So again, Mr. Chairman, Sean Taylor with the Wyoming Rural Electric Association. I appreciate Senator Steinmetz's introduction of the bill and the explaining the need for it. And you all have seen, and I've talked to you, you've seen the kind of the background and in our mind, the need for the bill. And I have some other folks here that'll come up and kind of give some context. I'll talk about the need
Are
for
you
it.
feeling pressure right now?
Not at all.
Because the missus just walked in.
Oh, God dang it. Now I do.
It's a small state. Keep going. I didn't mean to throw you off.
Oh, man, yeah, he totally threw me off now. So in our mind, Mr. Chairman, the need for the bill, as Senator Steinmetz mentioned, the certificated service territories are the lifeblood of any utility. And Senator Barlow, you're correct. This bill applies to all the utilities crossing boundaries. In our mind, the certificated service territory, that's our lifeblood. That's what we count on. We know that this is our service territory, and Senator Steinmetz passed out a map that shows the co-op certificated service territory. The rest of that, the white on that map, most of that is another investor-owned utility, Rocky Mountain Power. Some of it is also Black Hills, and then a small MDU is a small one up in the northern part of the state. So the whole state is divided up into these certificated service territories. We know that's our boundary. We know whatever load comes into that, whether it's one person, residential subdivision, or an oil and gas, or a manufacturer, if they're going to locate within that territory, that's not only our territory to serve, but we're also obligated to serve that load. And we count on that. As Senator Simons mentioned, any load to any utility is beneficial. And so we want to protect that territory. We want to protect our certificated service territory. And it's really about protecting our members as well. The folks that I'll have come up here in a little bit from Niobrara Electric, it's one of our smaller co-ops. And any load to that co-op or any utility is vital to reliability, rate stability, revenue. And so we want to make sure that we can continue to serve that. Now, when there's a violation, and I will say these violations don't happen very often. Traditionally, we've all, as Senator Steinman said, we've all played well in the sandbox together. But when there is a violation, not only in our minds is that against the law, the current law, but there's no repercussions for violating that territory. And that's why we wanted to bring this bill, Mr. Chairman, so that we stay in our lanes, the utilities stay in our lanes. We want to make sure that any new member, we call them member owners in the co-op world, because they own the cooperative. Any new member that comes in gets their power as soon as possible. I want to make that clear. And that's why we have these customer allocation agreements. And I asked all my co-op managers the other day if somebody could provide me with one of these agreements, and they're pretty simple. The one that I got was between High Plains Power up in your country, Mr. Chairman, and Rocky Mountain Power, and it was an agreement that said Rocky Mountain Power agrees to let High Plains Power serve this load up until such time when Rocky Mountain Power wants it back, and that's it. And if there's any infrastructure that's built within in order to serve that load by High Plains Power, then when Rocky Mountain comes in and wants the customer back or is able to serve it, then under this agreement, High Plains Power is compensated for whatever infrastructure. And Sean and Lindy with Niobrara can talk about what they've options that they've put out there in the instance. And the reason I have the folks from Niobrara is because this is kind of the straw that broke the camel's back. This example that they can share with you. How it's handled currently, Mr. Chairman, that's a really good question, and probably more apt for the Public Service Commission to explain. But currently, with the example that we have with Niobrara, and I've talked to all of you about that, there was a motion filed with the Public Service Commission to kind of figure this whole thing out. The entities were not able to come to a customer allocation agreement, and that's really the premise behind this bill, is to drive everybody, when we have this dispute or disagreement, if you will, we want to get everybody to a customer allocation agreement, so that this law, if passed, never really is used. If we have those customer allocation agreements, then we just move forward under that, and we don't have to go to court. And so the co-op filed a motion with the Public Service Commission. There's been a couple of different public meetings. All parties were invited to come and state their case. Currently, this instance is pending before the PSC. I think the next meeting on this is February 16th. So I think, to answer your question in a very long-winded way, my apologies, is that the Public Service Commission kind of handles them now. In our mind, if this bill were to become law, we wouldn't even get to the PSC. We would have a customer allocation agreement, and someone might ask, if you don't get to a customer allocation agreement, if the parties can't come to an agreement, then what happens? Well, in our minds, if that load is in our territory, then you have to go with us. Again, if it's a matter of getting service ASAP, as soon as possible, we got to figure that out. And hopefully the planning from any developer, whether again it's a subdivision or an oil and gas or a manufacturer, the planning is already, well in advance. They know that they're going to be in this co-op's territory or this investor-owned utilities territory, and they start the negotiations or the discussions with that utility. Every utility has a line extension policy and rules and regulations on how they operate and a rate schedule, and all of that is approved by the Public Service Commission. And so everybody knows up front what it's going to take to serve a load. And again, that's why I think the customer allocation agreements are key that this bill is driving everybody towards, because everybody should know upfront the costs. Let me back up real quick. We do have what we call indeterminate loads, and it's an oil and gas load. It's a crypto load. It's kind of a load that could be here today and gone tomorrow, given markets or the economics or whatever. And for those indeterminate loads, people have to pay the cost to get the power up front. So that doesn't put any of our members' investments at risk. And it seems only fair that if you need this load, then you pay for it to for us to build out to it. So I guess I would just say the last thing, and this is kind of the third rail in utilities in Wyoming anyhow, we are not a deregulated state. We are a regulated state, and Senator Case, Mr. Chairman, I know you know this all too well. And that means that there's not an ability for customers to shop around and look for the best case. Now, if we want to talk about deregulation, that's a whole different ballgame and not one to be, this bill does not deal with that. I think that could be an interim discussion if we want to talk about that. And we have plenty of empirical evidence that we could show that we think that's detrimental to particularly the residential customers. But so there is no ability right now to shop around. And in this instance where we've had this incursion on our co-op territory, it feels like that's basically what happened is the customer didn't like whatever Niobrara had to offer, and they did their own thing. They built their own line and hooked up to a delivery point in the neighboring utilities territory. And that shouldn't be allowed because, again, that's, in our mind, that's basically theft. That should be our load. And the utilities all know that. We all know that. And it shouldn't have ever happened, but it did. And so that's why we're asking for this bill.
Okay, thank you, Mr. Taylor. Questions for Mr. Taylor? Senator Barlow.
Thank you, Mr. Chairman. So to clarify, Mr. Taylor, this same scenario has occurred before. It's just that they reached an agreement prior to initiating the activity. Is that accurate? Thank you.
I think, Senator Barlow, I think some of the testimony would be that the PSC has been involved in these. So,
Mr. Chairman,
No need to
Senator
put words
Barlow,
in
you're
your
both right. I don't know of another instance where it's gotten this far down the road to the PSC, because we have reached agreements, customer allocation agreements in the past. If there is, possibly the PSC knows about that.
Further, anything? Anybody? Senator Boner.
Well, certainly look forward to the PSC's testimony so we can learn more about current law, but I guess I'll just ask the question bluntly. What happens when any utility can't provide service within their territory in such a way that it inhibits economic development? How do you deal with that challenge if we can't come to an agreement, we can't play nice? I mean, that's why we're here, right? That's the other side of the story. So how do you deal with that issue if you set up a hard and fast boundary and say, and you can't provide adequate service? How do we deal with that challenge?
Mr. Taylor.
Mr. Chairman, Senator Boner, and I might punt on that one and have the folks from Niobrara discuss that. But in our mind, we can serve anybody, anywhere. It takes time and money. And if the customer doesn't like that time and money aspect, I don't know what we do then, because we can, any of our co-ops, any utility, as long as we have the adequate time to build out, we can get to them. And again, if it's quicker and easier for a neighboring utility to get to them, we're fine with that. We just want to make sure we have a customer allocation agreement. And that's what should have happened in this instance. If it's easier and quicker for the neighboring utility to serve that load, we would allow that under the premise that once we build out our own line or the system grows and we are able to serve that load, then we can take it back.
Anybody else? Mr. Taylor, I'm trying to understand one thing. In your testimony, you said that the PSC is responsible for line extension and these kind of rates. But aren't cooperatives for the most part not under active PSC oversight? And I'm not sure that it's even happened, but they would come under, as I recall the law, they come under active oversight by the PSC if 5% of a customer class were to submit a petition asking for the PSC intervention. Maybe these customers are different, but I wasn't aware that the PSC had a role in setting these rates. Can you help me with that?
Yes, Mr. Chairman, you're right. So the co-ops, of the 11 distribution co-ops in Wyoming, 10 of them are not rate regulated, just for rates. They're regulated for everything else, line extension policies, rules and regs. The one that is not, the one that is rate regulated by the PSC, they chose to do that. They supported the rest of the co-ops getting out from under. And the reason we did this in 2005 or 6 is because the co-ops are self-governed, right? Our board of directors are elected by all the members, member owners of that co-op. We're nonprofit, so we wouldn't artificially increase rates to make a profit, because at the end of the year, we give those profits back to our members. So it doesn't make sense for us to artificially inflate rates. We do file our rates for those co-ops that are not rate regulated. We do file our rates with the PSC, so they're on record. They just don't need to be approved by the PSC. I would have to go back and look at the statute, Mr. Chairman, to be clear on what you're referencing. If there's a problem with a rate, anybody can contest it. They go first to the board of directors. And I'm very proud of the fact that since we got out from under rate regulation at the PSC, let me back up. Any customer can contest a rate to their elected board of directors of the co-op. If they're not happy with what they hear from that, they can take it to the PSC, any one person. The 5% is to petition to become rate regulated again. So it's kind of separate from what we're talking about today. And I'm very proud of the fact that since we've not been rate regulated by the PSC, there has not been one contested rate that's gone to the PSC. We've had a handful of folks that have questioned the rate, and they've gone to their local board, sat down with their board and the management, and they've gone through the rate case that the co-op has put together, and they walked away, maybe not happy, but understanding why the rate is set the way it is. So when I say that we have all of our stuff that's approved by the PSC, I'm mainly talking about the line extension policies and the rules and regulations that we operate under.
Thank you, Mr. Taylor. I appreciate that.
You got it.
Committee, it might be useful to think, I should disclose, I've actually worked for cooperatives, to help them with different decisions they might be making in their world. I've never worked for one in Wyoming. I did work for Northwest Iowa Public Service Company, and they are part of Basin Electric, who has interests in Wyoming. But my cooperatives are exactly that. They are an organization with a board of directors. Each customer gets a vote. They elect their representatives. They're very democratic. But my concern is it's kind of where you could make an analogy, and I don't mean to be crude, but it's like 4 wolves and a rabbit sitting around a campfire deciding what they're going to have for dinner, maybe sometimes, because the various customers have more votes when it comes to it. And a lot of these customers, and you're going to get your chance, I promise, Mr. Taylor, but a lot of them are agricultural based, and they may tend to have favorable rates for agricultural operations. Pumping, electricity pumping is one. So it certainly could be challenged that they have a tendency to try to keep residential and agricultural rates low, perhaps at the expense of other customer classes. Some of these might be these developments that we're talking about here today. But I do take Mr. Taylor's point that that has never been brought to the PSC. So I throw it back to you. Is that a possibility, since you kind of set your own rates?
Mr. Chairman, It's a loaded question.
Good morning.
I guess I would say that we do our best to not have any subsidized rate. I can't say with 100% certainty that doesn't happen, but we try very hard to not have any subsidized or cross subsidies within rate classes.
Thank you, Mr. Taylor. Senator Scott.
Mr. Chairman, I would comment, I've got experience with both REA and
Sure.
investor-owned utility. And I think the primary issue in these cases is often not the rates, but the ability to get service when you need it out in a rural area. And certainly my experience has been that the REA is much easier to work with and much more willing to accommodate business needs. Now, I expect that depends in some cases on the actual physical layout that they've gotten, where their power actually is. And, you know, we're talking, I think, largely oil fields that cross these boundaries. And the oil is where you find it, not where it's convenient for you to find it, Mr. Chairman. So, but I do think there is a real advantage in having an REA serving you.
Thank you, Senator Scott.
Mr.
Any other
Chairman,
questions?
if I may just
Oh, Mr. Taylor. of
maybe
course.
wrap this up, I appreciate that, Senator Scott. I just want to say that.
He would really like an REA to give him phone service. Is what
That's somebody else's department.
you, Mr. Taylor.
In the instance that we have today with Niobrara, I will say that the customer, when they decided, and I'm sure they're here in the room and they can speak for themselves, but they actually, when they decided to build their own line, they built 5.5, I believe it was 5.5 extra miles to get to the neighboring utility than to where they could have built to hook up to the REA. So in my mind, that brings up, are they shopping around for the best rate? And that brings me back to the deregulation versus regulated state. I think just to maybe wrap it up, in our mind, this is about fairness. That, you know, we have these territories for a reason. And if we start letting different, violations of the territories, then we're going to get into a mess. And I'll leave it at that.
Thank you, Mr. Taylor. Good
Thank you.
job. Who else would like to address this? Madam? You let your attorney go? How did Mr. Taylor do?
Nice work, Mr. Taylor.
Excellent.
No, the only thing I would point out real quickly in relation, if I may, Mr. Chairman, in relation to Senator Scott's point is these fields aren't planned overnight, these big oil fields. We all know how that works. I know of at least one situation where the big customer reached out to the REA in 2012, came to an agreement with another utility in 2014. Field didn't start operating until 2017. So there was 5 years in there where the operators knew that field was going in, and they're fast and they're good at what they do, and maybe it pops up what appears to be overnight, but the planning doesn't happen that fast.
And would you introduce yourself to us, please?
Sorry, Chairman.
It's on.
Okay, I'm Mandy Good with the law firm of Crowley Fleck, and I'm here as counsel for the Wyoming Rural Electric Association.
Thank you. Thank you, Ms. Good. Any questions for Ms. Good? Thank you very much. Who else would like to address us on this bill? Should we hear from Niobrara? Is that okay? Would that be appropriate? So it's, I like that it's Niobrara speaking to us because it was Representative Ross Dirks that brought the bill that allowed cooperative utilities to be excused from active rate regulation. So I hope he's still doing well up in your neck of the woods, sir.
Thank you,
To you.
Mr. Chairman. He is doing well.
Good.
My name is John Hester, and I'm here representing Niobrara Electric Association based in Lusk. I'm also the chairman of the board of directors at NEA. Just a little bit of history. NEA consists of 5,400 square miles of territory, 2,300 miles of line. We are the next to the smallest co-op in the state, and our load means everything to us. And we want to try to protect our territory, because any power that we aren't able to provide places an undue burden on the rest of the membership. We kind of are using the term here lately with the territorial boundaries subject, everybody needs to stay in their lane. And we treat all of our member owners exactly the same. We believe in equality among our membership. Our co-op consists of territory in Niobrara, Goshen, Platte, Weston, and Converse counties, with a chunk going over into Nebraska. Every citizen, member owner of our co-ops need, want, and deserve the protection of this bill as it is written and the protection it provides them. We are just afraid that if this trend continues where we have been encroached on, it has the potential of much further growth, that it will just continue to spiderweb out further into our territory. And I guess ultimately, we wouldn't be able to provide the service that we're providing our customers now, and revenue is a big thing, and we just need to have it so that we want our territory and for our membership, and also we have, regarding the territorial issue, there are statewide and nationwide implications to this. All of the co-ops in the state of Wyoming are supportive of what we're trying to do here. And they all have the same concern, that if once someone has moved in, where does that stop? And what company is going to go into another co-op? So, and this will actually set basically a precedent for what happens to co-ops throughout the nation. If they see that happen here, somebody in Louisiana may say, well, we can just run in there with our power. They did it in Wyoming, and I think it could spiral out of control very easily. I have with me here today our General Manager, Shauna Glendy, and you can make comments if you want.
Ms. Blendy, hi.
Hi, thanks, Mr. Chairman. The one thing I would like to address, as Senator Boner pointed out, what if we are not able to serve that load in that area? In this case, to where we do have an oil load that came into our territory and we do not have the infrastructure there currently. I understand that that can cause issues, but that is why we have the line extension policies filed with the PSC. Under those policies, it would be the responsibility of that customer to build that infrastructure, to get power from our current substations to where they want the power. If they do not want to build that line extension and the infrastructure to get there, we could possibly come to a customer service agreement with a neighboring utility who is closer and able to serve at that time, which at this point, that's what's happening. The other utility is serving in our territory, but without an agreement. They're taking all of the revenue away from our membership, and they didn't follow the policies that are filed with the PSC. So the importance of this bill is to prevent that from happening. We are not saying we're opposed to the neighboring utility serving this load. What we're opposed to is them doing it without a customer service agreement. So you can get into the weeds as much as you want as far as, money here and money there and, everything. But what it boils down to is another utility is serving in our territory without an agreement, which goes against state statute. So we would like this bill to be approved so that doesn't happen in the future. And this is not just a one-off. This has a potential, like Mr. Hester said, it could happen to all utilities across the state of Wyoming. And if that happens, that could be disastrous for the co-ops.
So thank you very much. Questions for either one of these presenters? Senator Landon.
Mr. Chairman, thank you. And Sean, I apologize, I missed your last name, but thank you for your testimony. My question just comes right to the heart of the matter. Why did this all break down? What happened out there? I just want your perspective from your side. What happened? Did somebody encroach like this?
Okay.
Go ahead.
Mr. Chairman, Senator Langdon. So that was before my time, but as Ms. Good pointed out, in 2012, negotiations started between the oil company and Niobrara Electric. And then in 2014, so they asked to start serving the load before an agreement was put in place. And as of 2014, the previous general manager thought that we were far enough into the negotiations that he would go ahead and allow it without the agreement, thinking that the process was going to continue. And then once we allowed them to take power from the neighboring utility, then all negotiations stopped with Niobrara. And so then we just happened to come across the line that they had built into our territory. We had no idea it was even there until I believe our operations manager was patrolling lines or something. And then we seen the line that was built into our territory, and then found out that, it was being supplied. Is that right in that context? Okay. And so then in 2020, I believe that the next general manager after him filed a complaint with the PSC saying we would like either some sort of agreement or the neighboring utilities stop serving in our territory, if that makes sense.
Go ahead.
So
Senator
follow
Landon.
up, Senator, Mr. Chairman, thank you. So when contacted, I'm trying to understand why the neighboring utility did not sit down at the table and work this out, because that's been the history of our state, really. I guess, and then the other question is, why is it taking so long for the PSC to rule on this thing? But prior to 2020, what happened when you went and sat down with the big neighbor?
Back to you. Either one of you, fine.
Mr. Chairman, the thing, once that okay was given for the oil company to put power to 2 or 3 oil wells while we were doing this negotiation, as soon as they got power to those wells, we didn't get any more communication from them. We couldn't get in contact with them. It's like they dropped off the face of the earth. And that all this time, they were just building like crazy. And I think the idea was to get in the door. And then once they got there, they've just been going. It's been a little while, to my understanding, since they've built anything. But as far as the neighbor to the west being involved, we haven't heard a word from them. They told us at a public service meeting that they had no way of knowing how much power was going into our territory, and the whole thing was totally false. Of course they know how much is going into our territory.
Mr. Chairman, I was going to say really, but yeah, go ahead.
No, that's fine. Thank you.
So just to be a little bit clear.
Yeah.
The person that built the line that you found, that wasn't the neighboring utility. That was the customer or someone acting on behalf of the customer. So they had all legal easements and things they must have had to be able to build the line. So, and then from the utility's perspective, the neighboring utility, they may look at it, and you may say this is wrong, but they may look at it, they're not really delivering into your territory. They're delivering into a customer line that has connected to them in their territory. So,
Mr. Chairman,
Go ahead.
that's exactly right. and that's how they've played it. They don't feel that they have any part in this, and we strongly disagree. They do have a big part in it.
Okay. And that's the issue that the PSC is grappling with right now?
Yes.
So-
Yes, Mr. Chairman.
So are we bringing a bill to, in anticipation of heading off the PSC? Is that what this bill does?
No, this bill is, Mr. Chairman, strictly trying to protect what territory is ours.
Okay. Senator Boner?
Well, since we're on the PSC, could you just give us your perspective on that process? How's it, where you at? What's been, I guess, what have you done and what do you expect? You say you have the next meeting in February, and what were some of the possible outcomes?
Yes, sir.
Mr. Chairman,
Are you involved in the PSC work?
peripherally.
Okay, I'm sorry. Maybe that was unfair, but tag it on to him.
Senator Boner, our interactions with the PSC have been difficult at best. We got a ruling from the PSC that said a lot of the things that we wanted to be said, but it fell short of coming out with a ruling saying on one side or the other, you will do this or you won't do that. And we're still in that process right now, and yeah, it has been frustrating.
Follow up, anything? Senator Barlow?
Thank you, Mr. Chairman. So thank you very much for being here. It was alluded that at one point, and I think this is maybe 2 managers prior to your tenure, that there was some kind of understanding with either the company who built the line and is getting the service, or the utility, that they would be, there was some kind of temporary agreement to allow service into that territory. What is the nature of that agreement? Is it a handshake deal? Is it a phone call? Is it I mean, obviously, it initiated somehow, so how is that? Thank you, Mr. Chairman.
Thank you, Senator Barlow. Yes, sir.
Mr. Chairman, Senator Barlow, it was at the point where it was just a verbal agreement. The process of getting the paperwork pulled together was in the process. But like I said before, once they got a power line into the territory, they no longer could be contacted, and that ended the whole thing.
Go ahead.
Mr. Chairman, so to be clear, was it with both parties? Is it what's actually being anticipated in this bill, i.e. in a customer allocation agreement between the 2 territories or public utilities and the customer, or is it just between yourselves and the customer? Thank you, Mr. Chairman.
Thank you. Either one of you?
Mr. Chairman, Senator Barlow, it was an agreement between us and the oil company.
Anybody else? Thank you very much.
Thank you for your time, and we hope you will support this bill. Thank you.
Thank you very much.
Oh,
Would you like to say something else? Please.
Sorry, Mr. Chairman. I guess, kind of want to say something to the effect of this bill and our situation. I mean, our situation is a good example of why this bill is needed. We don't want this bill simply because our territory is being invaded in. Obviously, that's a big factor for us, but this bill is for the entire state of Wyoming, and in our instance, the 11 co-ops that this could happen to as well. So it's a big deal for us. Like Sean said, we're a small co-op. We have a lot of ranchers. We have 1,300 members, that rely on us for reliable power. And when we have people coming in and essentially cherry picking our good loads, it does a lot of damage to our ability to be able to serve to our smaller members. So I just want to make that clarification that, like I said, this bill is for all of the state of Wyoming, not just Niobrara, but we're just being used as an example as to why it's very important to everybody.
Thank you very much for that. But you did mention, of course, that this was a new load, right? You hadn't been serving this load. So it's kind of a reach to say that it hurts your customers.
Well, I guess
it hurts their potential position, perhaps. but it's a new load, and it's
Yeah.
not removing it from your load you were serving previously. Is that correct?
That's correct, Mr. Chairman. I guess I was looking at more of, for the last 6 years, we have lost that much revenue that we could have been, being given because that load is in our territory. So,
Right.
yeah, at the time, in 2017, we did not have that load, so it was. But over the last 6 years, we've lost significant revenue by another member serving. in our
True, but if your rates are too high for that customer, that they may not have even developed without this opportunity, you wouldn't have lost that in that situation either. And I don't know that. That's total speculation. Senator Barlow.
Thank you, Mr. Chairman. So this brings up another thing that I'm familiar with in my country, where we have central metering, where we have a central meter and it goes out to customer-built lines, et cetera. And actually, there's, at least in the area I live in, I think they are trying to eliminate those or reduce those because of other challenges, such as maintenance of the line past that delivery point or past that metering point. So I guess my query is, at what point in this, well, when would you have continued that central metering type process? And it sounds like this possibility could have actually served loads in both service districts. This line actually service lines and loads in both service districts. So is that also a place where a customer allocation agreement, electrons don't care where they go, and they don't care who produces them or what they're produced from. So is that also a place, or is there actually hard lines between these service areas? Thank you, Mr. Chairman. Hard lines as in stops,
Who'd like to
breakers.
address
Thank
this?
you.
Thank you, Mr. Chairman. So we have a couple of proposals out there with the oil company whose load is in our territory, and that is actually one of the proposals, is that at the end of where the neighboring utilities load stops, and then the member that's into our territory, they put what's called a deduct meter there. So basically, from that metering point on, they'll say this is how much load is in Niobrara's service territory, and then pay for that accordingly. And then the load that's being served in the other territory, they would pay the other company for that. So basically, it's just, we put a meter there, and this is our load in our territory, and this is your load in your territory, which to us seems fair.
Right. Thank you. So thank you both. I'm conscious of the time. We have another bill after this one, and so let's try to speed it up if we could. So who else? Public Service Commission, so we get you guys first. I realize this is a pending issue before you, and we'll limit probably what you can say about it, but love to have your input. Welcome, commissioners. Welcome, Mr. General Counsel.
Thank you,
Mr.
Mr.
Petrie.
Chairman. Chris Petrie, I'm Chairman of the Public Service Commission. With me today are Commissioner Mary Throne and our Chief Counsel, John Burbridge. As you note, this is a live docket in front of the commission, so our ability to delve into details on that would be pretty limited. I'll just start off by saying that we are basically indifferent to this bill. I shouldn't say indifferent, but we're neutral on the bill. There are three things, however, three spots in the bill where I would suggest that insertions would be beneficial. The first is on page 2 at line 1, after shall, to insert the word knowingly. As you may know, public utilities are generally provided with some protection from common negligence and liability in order to protect their customers from that liability. And so in the case where a utility is not aware of customer building facilities into the territory of a neighbor, it seems that it would be perhaps a step farther than anybody would intend to go to thereby expose them to litigation and potentially liability. There's also an aspect to this that relates to how these things have been handled in the past. For that, I'd take you to Also, I would also like to discuss another insertion in line 8 of the same page, where I would suggest inserting after subsection commenced after July 1, 2023. There are many customer allocation agreements in effect around the state. There have been many circumstances over the years that called for it, often because it was beneficial for the customer, as has been discussed, perhaps faster, perhaps cheaper, and those have been put into place, generally with commission approval. However, there are instances where these arrangements may not have been well documented, and I'm reaching back into the past, but in modern times, so to speak, these customer allocation agreements are presented to the commission for approval. Once they receive the commission's approval, they're in effect, as Mr. Taylor described it, they're generally not terribly exotic agreements, and his explanation was correct. However, it seems that it might cause problems to craft this bill or a new statute in a way that suggests liability and potential litigation for existing circumstances that may not be subject to proof by the kind of documentation that we're used to today. The third area that I'd like to highlight and suggest that it might be beneficial to make another insertion is on line 8 after utilities, to insert approved by the commission. As I think has already been explained, the Public Service Commission has established the service territories assigned to the various utilities, including all the electric utilities and all the cooperatives. And the commission has always understood, and I think that's what's provided for in the statutes, that the commission has continuing jurisdiction over those service territories. And so it wouldn't be helpful to suggest that two utilities and a customer could, between themselves, alter those service territories without the commission's involvement and the commission's approval.
Okay.
Mr. Chairman, I'm happy to answer any questions.
Questions for Mr. Petrie? Senator Landon, questions for the chairman? Go ahead.
It's kind of an elementary question, Mr. Chairman, but does this fall on your purview, and is this the kind of thing you rule on? What you're hearing this morning?
Chairman Petrie.
Mr. Chairman, Senator Landon, we do consider certificate of public convenience and necessity territories, the certificated territories. So yes, the commission has, through the years, established and at times altered service territories. For example, if you looked at gas service territories for natural gas utilities, you would see that over the years, some of them have grown. As the utilities expand, they would come to the commission, at least in some circumstances, and request the commission's approval to expand their service territory into a larger territory. There have also been occasions where the commission has altered a service territory because the public interest required it. And I just say that certainly the well-being of our public utilities is crucial. We absolutely understand that everybody in the state needs to have available to them safe, adequate, and reliable service at just and reasonable rates. Sometimes that does touch on where the service territory boundaries actually are. There have been occasions where a customer has complained that under his particular circumstances, the rates of the incumbent utility are not just and reasonable. And usually they would be pointing to a circumstance where their proposed use was very close to facilities of a neighboring utility, but not the one assigned to the spot where they intended to build a house or conduct some activity that needed electric service. In such a case, the commission could agree with that customer and say, yes, it's not reasonable. It's not a reasonable rate for you to have to pay a line extension to build 5 miles of line from the incumbent utilities facilities when you are 300 yards from the neighboring utilities facilities on the other side of the road.
Mr. Chairman, looking at the committee, if a private entity like an oil company wants to build a power line from point A to point B, do they have to get a certificate of convenience and necessity from you?
Mr. Chairman, they do not. The Public Service Commission's jurisdiction extends to public utilities, and it's a defined term in every category: gas, transportation, pipelines, electricity, and water. And their customers are not really subject to the commission's jurisdiction generally. There are some exceptions where the commission can exercise its authority. For example, if a customer is operating or if a customer's premises is unsafe, the commission could then direct the utility to cease supplying service in an unsafe circumstance.
That's my recollection too. So anybody else from the commission like to address the committee? Commissioner Thron, welcome.
Good morning, Chairman Case, Senator Case, members of the committee. Nice to see all of you. I just wanted to make a couple of points. I think that the last discussion and the comments of Chairman Petrie covered the main points, but I didn't hear anybody mention that the utilities have a duty to serve. They have a duty to serve in their certificated territory. And if they can't fulfill that duty to serve, the customer can come to us and complain. We have a complaint procedure. So there is a procedure available, and it was used in the case that you've heard a lot about, but not by the customer, by the REA. The customer did not come in and complain. The customer's now intervened, and that's procedurally where we are, and that's, really all I can say.
I understand.
I just want to remind Mr. Chairman, I know during the session you don't have a lot of extra time, but we did send you the order in this case during the interim. Happy to send it again, but I don't know that you have time to read it now.
Would you please send it to the committee? That'd be great.
I'll send it to your secretary. Thank you, Mr. Chairman.
Thank you, Commissioner. Questions for Commissioner Thron? See, somebody made good after being in this great legislature. Anybody else? Thank you, Commission. Thank you very much. Stay close.
And
Who
Mr.
else?
Chairman, I found my pin.
Oh,
I thought I
that
had
famous
lost this pin.
Did Greg Schaefer give you that pin? Yeah. Who else would like, Mr. Nelson, come on up. So just conscious of the time, we have another bill, we have an agency here. So we have another bill on unemployment. So let's hope we can get through this. Mr. Nelson.
Thank you, Chairman Case, members of the committee. My name is Thor Nelson. I'm an attorney at the law firm of Holland and Hart. I am wearing several hats in this context, but I want to be specific about the hat that I am wearing. As many of you know, I do work for an organization called the Wyoming Industrial Energy Consumers, which is a coalition of large energy consumers throughout the state of Wyoming. And those are the people whom I am here for today, in particular. However, just by way of full disclosure, I also am representing the oil company that is involved in this dispute with NEA and Rocky Mountain Power, which is Continental Resources. And so just as an FYI, I do represent them at the commission, but I'm not here for them today specifically, but I am aware of the situation, obviously.
Boy, what a broad wave you paddle out there.
Well, you know,
All shores.
try to monopolize all industrial consumer representation in the state. That's my business
You
model, as
seem
you
to
well
be
know.
doing well. You've even got the wind guys. Keep going.
I rise today in opposition to the bill that's before the committee, and I urge the committee to vote no on this legislation. I want to explain why WIAC recommends that the committee vote no on this and why we think that the current approach that is on display in the matter before the commission works just fine and is in the public interest. A couple of things that are important to note. The reason why there is controversy over this legislation is because of two words in the bill, the words "or indirect." If you look right at the very first sentence, it says, "No public utility shall directly or indirectly, blah, 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 blah." It is that "or indirect" that causes all of the problems. And the reason that is because in the ordinary course of life, if a utility is directly serving a customer, they know where those facilities are, they know where those lines are, they know where the service territory boundaries are, and they know when they're going to cross them. And in those instances where that occurs, as has been explained by previous witnesses, we have a routine and general practice of negotiating these arrangements between the utilities to try to decide how to treat those customers. And so when the utilities directly serve the customers, everybody knows what they're supposed to do, and as far as I know, there is no allegation of anybody directly serving in violation of somebody's service territory. This whole issue comes up, and it comes up very rarely. I was talking with the commission counsel earlier, and I think there was maybe like 2 times in the last 40 years that we can think of that somebody has raised this issue, is the idea of an indirect service. And an indirect service happens because in Wyoming, it is perfectly lawful for a customer to construct his own electric lines on his property or controlled property to serve his own loads. And this doesn't happen only in the oil and gas space, but it does happen there. So in the oil and gas space, you have an oil and gas field, you have a service coming in from a utility, and then the customer builds his own lines throughout the field, and they do so because they can do it cheaper, they can do it quicker, and they can do it more efficiently than if the utility does it for them. And the utility likes that oftentimes because then it's the customer who has the risk of those lines. If the wells aren't running, the customer has the risk, the customer fronts all the money, so it works well for everybody. But it's not only oil and gas. This happens in ranches, it happens in farms. You've got people who are running lines to barns, people who are running lines to water wells, to irrigation systems. I mean, you have people in large pieces of land running their own little small distribution systems all the time. And I can guarantee that there are ranches and farms in Wyoming who cross utility service territories and have no idea that that's happening. And I can guarantee that they're running lines across their internal facilities to serve their loads and have no idea that they're about to be in violation of the law if this bill passes. And so while the oil and gas industry and the issue that's been raised is certainly the most public example, I would urge the committee to please be careful, because there are almost certainly many instances of this indirect service happening right now that just nobody knows about or frankly cares about, because if the loads are only small, irrigation wells or a barn, nobody cares very much. They only care when the dollars get big enough because the load is big enough. Now, having said that, because there is no prohibition on customers doing these constructions and making these facilities, the nice thing is that the current system in place applies a level of flexibility to these issues in the rare instances when they do come up, and that's what we've seen here in front of the commission. That instead of establishing a bright line rule that the bill proposes, what the commission can do is employ flexible ideas and employ the public interest and make judgment calls, including a judgment call about whether or not in a particular instance you actually should change the service territory boundaries in order to reach a result that's in the public interest. The service territory boundaries are real, but they're not like the tablets brought down by Moses from the mountain. They can change. They can be adjusted if the circumstances warrant it, and it is in the public interest of Wyoming for that to happen. With the legislation that's before you, it takes it out of the commission's hands into the court's hands, and the court doesn't have the ability to use that tool in order to achieve an equitable outcome. And so fundamentally, one of the struggles we have with this whole concept is that by taking this into a civil litigation approach, you are depriving the decision maker of one of the important tools they have to achieve the public interest, and that is potentially to decide if the territory boundaries themselves ought to be adjusted. The other issue that we have in the context of the legislation is we think that it will create potentially what I'll call unintended consequences. And here I'll focus in particular on the last portion of the bill that speaks to the penalty that the bill proposes to create for a violation of the law. One of the important issues of this, the chairman of the commission already addressed, which is the knowing element. The idea that because these are customers who are extending these facilities, perhaps and typically without the utility's knowledge that that's happening, the idea that the utility would then be subjected to a penalty for that, even if they had no idea that it was occurring, I think is troubling as sort of an issue of fundamental fairness. And so certainly something would need to be done if this bill goes forward to address that concern. Another issue is the measure of the penalty. You'll note that the penalty proposes to measure lost income, not lost profits. And I mention this because if the situation is occurring that one utility is indirectly and serving a load, that utility is incurring costs associated with that service. And as was discussed with the representatives from NEA, the utility who is not serving is not imposing costs. And so I would argue that the idea of imposing a lost income standard instead of a lost profit standard overcompensates one utility at the expense of the other for no good reason. But the most important problem here relative to the penalty is the timing. Now we have to get to the real world. In the real world, these situations cannot be resolved by the flick of a switch. What has to happen in the real world is if there is an issue like what happened in the Niobrara area, you have to build new construction. You have to build sometimes lots of new construction. In the NEA case, we're talking about hundreds of thousands or millions of dollars worth of new infrastructure has to be built. And that has to happen before you can take any action to actually change the status quo. So let me walk through what would happen potentially. This bill passes, someone brings a lawsuit, we'll use the situation in continental NEA as an example. The lawsuit comes, Rocky Mountain Power has said, okay, thou shalt not provide service to customers in the NEA service territory. Well, as was indicated, when Rocky Mountain Power delivers service, they do that in their service territory, and it's carried over the customer lines across the boundaries. Rocky Mountain Power has no ability to stop the power flowing across the boundaries. In order to figure out how to do that, you have to construct new facilities, deduct meters, for example, or other new lines to physically disconnect the two halves of the customer-owned system in order to serve the NEA part. So because that can't happen overnight, and because the utility is now saying, well, we're subject to all these fines, the only solution Rocky Mountain Power has is to shut off the entire field, both the one part in their service territory and the part that goes across, because that's the only place where they have the control at the point of interconnection between the utility and the customer. And so the challenge is that you create a situation where, again, unlike the commission process, where you can be flexible, you can deal with timing, you can address the fact that construction takes time, and so we're going to have some sort of managed transition. Unlike that sort of flexibility in the process contemplated by the bill, it would require instantaneous action, which could only be effectuated by shutting off the entire field until such time as all of that new construction were accomplished, which could be months or years. And so structurally speaking, the very, for what I'll say, sort of bright line draconian nature of this legislation, we think is overkill. And we would argue that the current process, where, by the way, the commission ordered that NEA should ultimately serve this customer, they only did so with the caveat that it not be at a substantial cost to the customer. And it is that element, I suppose, that NEA has a concern with. But ultimately, the commission said, NEA, you should serve this customer, subject to managing a transition to make that happen. That solution is working. And so this proposed legislation goes way too far and is unnecessary. And for those reasons, we would ask the committee to vote no. Thank you. I'm available for any questions.
Thank you, Mr. Nelson. I'm going to take a time out here before we get to questions. So how many people want to testify on this, this bill about the Senate File 105? Got 1, 2, 3. Okay, so I'm going to make we're going to do an audible here. I think the best thing to do would, rather than try to jam Senate File 121 in this morning as well, and we've got these people waiting, if it's okay, we will take Senate File 121 up on Thursday morning. And we're going to have a heavy schedule on Thursday too, but, and perhaps the parties could talk a little bit about 121 and appreciate it. So if you're here for indexing unemployment insurance, either present or online, we'll take that up on Thursday for our first bill. Okay, questions for Mr. Nelson? Questions for Mr. Nelson? Senator Scott, do you have a question? You got that look.
Mr. Chairman, why was there no effort made to change the service territories? There was some testimony that was possible, but I gather there was no effort made to do that?
Mr. Nelson.
So, Mr. Chairman, Senator Scott, so first of all, I have to caveat that at the time that this first started, I wasn't helping the predecessor to Continental. And so I only have some information about that. And I believe the answer, based on what I know, is that there have in fact been discussions about essentially a service territory swap. And I think that the representatives from NEA intimated this as well, that there's always been two paths of possible outcome. One is not a permanent swap of the territory, but a temporary agreement where Rocky Mountain Power would serve the load for some period of time. There would be some payment made by the customer to NEA, and then at some future date, possibly when there were other customers in the area that required facilities to be built, that customer would then switch over. So nobody ever talked about a permanent shift, but a temporary shift absolutely was, and I think fairly still is on the table as an option. Then there's other options which are direct service from NEA, which are also have been and are being explored. So I think the answer to your question, Senator, is that that has been discussed and is still a possibility. It just hasn't been executed at this time.
Senator Scott.
Mr. Chairman, the Public Service Commission suggested putting in an amendment on page 8. This would apply for
Page 2, I believe.
Page 2, line 8, excuse me, commenced after January 1, 2023. Would that amendment remove many of your clients' concerns?
Mr. Nelson.
So first of all, not here for that client, but I'll still take a shot at this, Senator, Mr. Chairman, thank you.
Okay.
So the tricky part about the commission's language and the part that I honestly have not fully thought through is the service, electricity service is sort of continuous. You do it all of the time. And so I'm not sure I know exactly what it means by commencing. I.e., is it the first moment when electricity was taken by a particular well? Is that the triggering for commencing? Or is the idea that it is, that in a new month, we now have a new bill for service to that well, and so service has commenced? And so I appreciate the objective of the commission, which is to sort of, if you would, grandfather in this current dispute. I'm not 100% sure that language does that, but I do appreciate the fact that trying to take the issue that's currently before the commission and leave it in the process it's in would make sense, and I think would certainly help the situation, because I think it is problematic to try to have a sort of a dueling legislative solution while at the same time the commission is adjudicating a particular case.
Okay, thank you. I'm going to try to speed things up a little bit, if it's all right. I mean, anything else from Mr. Nelson? We've got, I saw 3 more witnesses. I'd like to finish this testimony by 9:50, and we're going to vote on the bill at that point. I can't do any better. So, Mr. Nelson, thank you. Who's
Thank you.
next? Right behind you. Yes, sir. We're really short on time now. Thanks to all these long-winded people before you and nothing to you. Go ahead, sir.
Well, thank you, sir. My name is Todd Fornstrom. I am the president of the Wyoming Farm Bureau Federation. I'm just a farmer, so I'll keep it quick. I'm not an attorney. I guess I would rise in favor of this. I would urge you to vote in favor of it. As a farmer and rancher representing 27, roughly 100 members within the state of Wyoming, The rural electrics associations have been the way that farmers and ranchers have gotten electricity since probably the mid-30s, I think, is when the Electrification Act came into effect. And these boundaries are what keep these cooperatives whole. And without those boundaries, you get a bleeding in, cherry picking back and forth of those, of the cooperative. And if that continues to happen, I could see a deterioration of those cooperatives. I represent myself as a farmer. I'm a big power user. I have a large industrial milling capacity, and I'm also a resident user, 3 different metering types, all from the local REA. I understand the differences in rates, and they're there for a reason. So I would urge you to vote in favor of this, and I would stand for any questions if you have any.
Thank you, Mr. Fornstrom. Any questions? Thank you, sir.
Thank you.
Who's next? Mr. Obermuller. You guys just both coming up together? That's great. No worries. Thank you. Mr. Obermuller.
Trying to save a second or two, Mr. Chairman. We're not testifying together, just so you know.
Just
representing
sitting
our own.
together.
Yeah, exactly.
By implication.
Thank you, Mr. Chairman. Pete Obermuller, President of the Petroleum Association of Wyoming. Mr. Chairman, we have a lot of concerns with this bill. And as you have heard, and we could probably talk about it for another 2 more hours, there are so many layers about this bill. Fundamentally, it is brought because of one situation, a very rare situation, and that is unlikely to happen in a lot of cases, but has happened here for a lot of reasons which I will get to. So I think, Mr. Chairman, just generally, it's pretty clear that we have a very inefficient system in Wyoming as it relates to providing electricity service. Now, it doesn't really matter when a project is within one territory, and we're not asking for here, or have we asked for the ability to shop for the utility that we take electricity from. If you're in a territory, you buy the electricity from that provider, and you are required to pay the infrastructure. This is the cost of doing business. I think it's an interesting highlight of our inefficient service that you hear testimony that that the load means everything, and that it's very important to spreading the rate and all of that. And so, an oil and gas project is, of course, really important, but then that they're indeterminate. They're here today and gone tomorrow, in Mr. Taylor's words. And so because of that, then, of course, it's on us to also build the infrastructure. So it's an interesting incongruity in my mind. So, Mr. Chairman, the trouble is, we understand that it's our obligation to pay for the infrastructure and to live within the confines of the territories where we exist. The trouble is that this bill asks us to pay twice in a case where it is a split territory, is what happened in the current situation that brought rise to this bill. So we paid to build it out from the original utility, and then you pay again under this bill for lost income over that time. Now, the rural electrics say that, of course, and that the original utility has to pay for it, but the utility cannot police that. The only way for them to deal with that is to put in the original contract and tariff with the customer, that if that happens, then it's on us to pay for it. So we pay for it twice. Essentially, it makes it explicitly illegal to be able to build an oil and gas field in a situation where an agreement cannot be reached. And our interest throughout this entire process has been to leave an avenue open to make sure that an oil and gas project can move forward in these cases. Now, we're perfectly fine with some sort of working out some sort of scenario where the PSC is either required to act in a certain amount of time, or has some other avenues to require a switchover. But for lots of reasons, it's taken a long time in this case, so we do not want it to be explicitly illegal, Mr. Chairman. So really quickly, just on the case that brought rise to this, lots of discussion about a former PAW member in this case and whether they were at the table or fell off the edge of the earth or whatever. We heard one side of that, Mr. Chairman. My former member would dispute that characterization. Now, we're not in a court of law, so it is what it is. The important part is that member is no longer in Wyoming. a new member has come in and purchased it, and they were very incentivized, very interested in resolving the situation, not just for the situation itself, but so that we wouldn't have a bill like this to try to solve one situation. And they offered very novel approaches to solving the issue, and yet the demands kept coming, and so those negotiations broke down, and so we're still at the PSC, Mr. Chairman. So in our opinion, negotiation is a two-way street, and it broke down for lots of reasons, unfortunately. And here's where we are. So, Mr. Chairman, we believe that the current process works, that the PSC can and should act, and a lot of it is determined upon deciding whether or not a utility is ready to serve. And if they are, then of course we can effectuate the switch. So, Mr. Chairman, we'd prefer that the bill not move forward, but if it does, there's a couple of things that we would like to ask you to do. Number one, the PSC's language I think is helpful. Mr. Nelson is a great attorney. You got some good on the one hand, on the other hand regarding that language. I think it's helpful in the sense that it does not, I think it does not affect the current situation at the PSC and moves it to a prospective language. The other one, Mr. Chairman, is that on page 2, starting at lines 8 and following, understanding Mr. Nelson's point about income versus profit, I won't make a point about that, but I would ask that you put a period at the end of income and delete the rest. Mr. Chairman, I think we in this state know more about the perverse incentives caused by rate shifting, fee shifting, where we put in statute that one person is going to pay for attorney's fees and costs. Those types of statutes are generally in place to protect the littlest of actors against the biggest government intrusion. My members, Mr. Nelson's members, Mr. Taylor's members, we're not small actors. We can and should defend ourselves in these cases, and fee shifting statutes like that, it provides a perverse incentive and is just generally bad policy. We'd ask for that to be removed, Mr. Chairman.
Just to be clear, you had said line 8, but I think you meant line 10, right?
I'm sorry, Mr. Chairman, you're exactly right.
So
line
put-
10, period after income.
Your proposals put a period after income?
And strike the rest.
So strike all the way down through line 14?
That's correct, Mr. Chairman.
Okay. Keep going then.
And finally, Mr. Chairman, I don't have suggested language here, and it was brought up before, that I do think that perhaps in these cases where there's a large desirable project that splits boundaries, that there should be perhaps a more streamlined process where we can ask the PSC to evaluate the boundaries and perhaps change the boundaries. They are not sacrosanct, and they ought to be evaluated in these cases for efficiency's sake. Because at the end of the day, it's not just our interest here; it's the state's interests. These fields, the field in question has many wells, much revenue to the state and to the schools in both counties. And it's important to the state to be able to keep that going. Mr. Chairman, I'm sorry for speaking quickly and stumbling over myself.
Okay, any questions for Mr.
Honor your time.
Obermuller? Any questions? Thank you, Mr. Kaysen.
Okay. Thank you, Mr. Chairman, members of the committee. My name is Rick Kaysen. I represent Rocky Mountain Power. I will not get into many things have been said, and they're all valuable, and I hope all of this is registered. But a couple of things that I do wish to emphasize, and this has already been shared with you. This bill is talking about something that's been practiced in our state for decades, for 100 years. And the utilities have, for the most part, have respected the certificated service territories. You heard earlier that the Rocky Mountain Power and the Niobrara incident is a rarity. So again, I think this tells us that there is a workable cooperation, or there has been workable cooperation between utilities, and that can continue in the state. The other things, and again, Mr. Chairman, recognizing your time, this bill may not alleviate all possible situations, and we heard some allusions to that as well. And what I mean by that, there is an expectation of utilities to serve in this state, and to serve promptly, to serve adequately, safely, and at the best rate that can be provided. So there is an expectation. The customers also have an expectation for that service to be there as soon as possible because they have a definitive interest in this. And so, again, this bill may not be able to address all of those potential situations. Other comments, sir, but with respect to time, and I will stand for questions that any of the members may have.
Thank you. Any questions for Mr. Kaysen? Any questions? Thank you both. Stay by.
Thank you.
Kelly, is there anybody online? Okay, and is there nobody else in the room? Committee, you've heard the testimony. What is your pleasure? Motion by Scott. Proposed amendments?
Mr. Chairman.
Senator Scott first, and then we'll go to Senator Barlow. Go ahead.
Mr. Chairman, I would move on page 2, line 8, after subsection, to insert commenced after July 1, 2023, as per the Public Service Commission recommendation there.
Did you want to offer any of their other amendments or just that one?
Just that one.
Okay, discussion? All those in favor signify by saying aye.
Aye.
Any opposed? Okay, Senator Barlow.
Thank you, Mr. Chairman. So I would move the other two suggestions from the Public Service Commission, knowingly, line 1 after shall, and approved by the commission, line 8 after utilities.
Okay, discussion? All those in favor signify by saying aye.
Aye.
Any opposed? No by Scott, no by Case, but I think it's carried. So that is carried. Anything else on the bill? Senator Landon.
Mr. Chairman, I would move the amendment proposed by petroleum folks, line 10, after the word income, insert a period, strike the rest of that paragraph from all the way to line 14.
Discussion? Senator Barlow.
So, Mr. Chairman, thank you. So I should have intervened, or should have said something when Senator Scott made his initial first amendment. It seems like this section, is there any prohibition against litigating on any issue? And yet we're pointing out this subsection specifically for litigation. And my motion would have been to strike all of that entire sentence and the remainder, saying that I mean, if there's a challenge and they don't like where they are, et cetera, but this is specific to this subsection, not to anything else entirely. So it seems like they have that ability already, and maybe I'm wrong. Maybe they don't believe they have that ability, but this seems, anyway, thank you. I'll support it, but I think, I don't even know we need this entire sentence. Thank you, Mr.
So
Chairman.
just to be clear, Senator, your point is that you always have the ability to sue, so, but you're not specifically against the amendment which modifies the second half of that section. Okay, I think we're clear on that. Everybody else? All in favor of Senator Landon's amendment, please signify by saying aye. Aye. Okay, any opposed? Okay, we're back on the bill. Let's have discussion on the bill. I think this is a bit unusual in dealing with a specific case, and I don't think I will be inclined to support it. I do, people need resolution of these issues at the PSC, that's for sure. So I'm not sure what happened there, and I'm not trying to put you on the spot, but this is an important issue. But everything that was done was a private company. They built their own line. It wasn't the utility poaching the customers. So that's where I come out on it, but please, other folks, anybody? Senator Landon.
Mr. Chairman, thank you. And I know we're running out of time.
Well, we're just going to be late for caucus, but we're not gaveling in.
There you go.
So
Well,
we hate caucus.
This is a tough one, and just in the interest of full disclosure, I used to work for the rural electrics. I worked for the late Senator Craig Thomas.
Sure.
And I have a couple of facilities in a co-op up in the western part of the state. So I have a lot of connections there. I also represent a district that probably has more oil and gas service companies than maybe anyone. So I have friends on both sides of this bill, and I plan to stand with my friends.
There you go.
There you go. Borrowing a quote from Senator Coe.
Anybody else?
So,
I'm sorry, Mr.
Chairman, just a final thing. This is a little heavy-handed for me. I think what happened is we have referees for these games. I think the referees didn't make the call. And we're kind of toward the end of the game and we're all looking at each other going, well, how come the block charge wasn't called? It's either a block or it's a charge and we go that way, and it didn't happen. So I'm really struggling with this bill. Thank you, Mr. Chairman.
So, and just, we should defend the Public Service Commission. We have no idea why this has taken so long. Honestly,
I agree.
I don't have a clue.
Thank you.
So, I have, we've given them a lot of burden of work, and so I'm sure they're doing the best they can. Okay, so, anything else on the bill? Would you call the,
Mr. Chairman.
oh, Senator Barlow.
Thank you, Mr. Chairman. So I'm actually supportive because it seems to be codifying what we believe has always been done in the past. We had a breakdown. Now, I would argue that what this bill does, it actually doesn't probably change the outcome of what happens here. It just maybe change the pace, which it may be addressed the next time. And hopefully to the benefit of all. So it seems like this is just saying, yep, this is how we should be doing. This is how we thought we were doing it. We had a breakdown. Thank you, Mr. Chairman.
Thank you. Anybody else? Okay, let's call roll on the bill, please. As
Senator
amended.
Barlow? Senator Boner?
No.
Senator Landon? No. Senator Scott? Mr. Chairman?
No. So the bill has failed on a 3-2. So thank you all. Thank you all for coming. We'll take up the unemployment bill on Thursday. We'll probably take up Senate File 92 on Thursday. And I'm toying with Senator Scott. We need to figure out when we're going to hear your bill. And I hope it would be Thursday too, but it might mean that we're going to have a noon meeting after our morning meeting. So I'll put you on notice. Okay, thank you.